With Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Matafuro, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the individual rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
To know how we can give opinion to your issue, your question. Back to Mr. Wallaby. Matthew, so we've dealt with Article 8, which is very key to this application. We also dealt with Article 3, which is very important, and also other circumstances in medical as well, is things to look into in discussing this application. You mentioned about asylum seekers. You know, most of them will be thinking, and I think it's important I go into this a little bit, asylum application, because discretionary leave can also be granted once an individual has made application for asylum. And that could be considered if the person fails asylum or to be recognized as a refugee. The Home Office, Secretary of State, can consider, discretionary leave to grant or humanitarian protection. Now,
indeed, yeah.
To grant that. Now, if individuals claim asylum and then humanitarian protection is granted, then what happened to discretionary leave? That means one stands, the other falls.
So you cannot have two grants of leave. So it's either you get HP or you get DL.
DL, which is discretionary leave to remain. Right. And as obviously we said that anybody can claim this, make this application, and to see how the Home Office will react to that. Now, the key important question now is that some people have this fear that once they make this application, and that means they have now put themselves out to the Home Office. The Home Office have got their details and their address and can come after them. My opinion is always, it's better you engage than you getting arrested. And in that case, you don't have any more opportunity to rectify the error. What have you got to say to that? Because it's very important. Most questions we get is that, what if this application fails? And then obviously the Home Office will come after me.
Let me suggest that it's a question of individual preference. However, we do understand the underlying law. If you're in the United Kingdom unlawfully, that might be a criminal offense. So we don't want to be condoning criminality here. However, the Home Office takes it seriously when someone engages with them, when someone seeks to regularize their status in the United Kingdom.
Right.
Whether it's done by application, which will subsume the discretionary leave points. That's something for the Home Office to consider, and the sooner it's done, the better. Actually,
the sooner it's better. Obviously, the reason why we're saying this is that if you make your application to the Home Office and the application is pending, and perchance, the Home Office comes or the enforcement agents, come across you, then you stand a little bit of chance that you've made application to regularize the stay, rather than a fire brigade approach, having been arrested. Because yes, if you are staying in the United Kingdom illegally, that is a criminal offense under the new law. But it's important. That's why this program is to educate you, so that you don't just sit down on your right. Take a step, engage with the law, and the law will be kind to you when you finally come under the net. Now, Mr. Olabi, discretionary leave to remain application, if granted, how many years granted to?
Generally, it's granted for up to 3 years in the first instance. So you get a grant of 3 years for unaccompanied asylum-seeking children. It's normally granted until they turn 17 and a half, depending on their particular circumstances. We should mention. And then it's if you get a grant of discretionary leave to remain, of course you can always extend it after the 3-year period, and something known as the active review kicks in.
Yes.
But after 6 years, you would be able to apply for indefinite leave to remain.
Absolutely. That's another very good point, because you see, that's why this program has been initiated. People who have been sitting and sleeping on their rights or not knowing option to take. this can wake them up to know that they can take action immediately. And from 3 years, you should say, to another 3 years, and 6 years, and they'll be qualified to apply for indefinite leave to remain in the UK. Yeah. Now, if that application has been refused by the Home Office, some people always have this issue about appeal. Is there any right of appeal?
Now, that's a critical question here. It's a bit technical, so it might be something you want to deal with in the office. But I mean, your program is Law Simplified with Justice, so let me simplify that as best as I can.
Which is what it is, yeah.
Generally, you would have a right of appeal if you have what is known in legal terms as an immigration decision. Now, we have an Act of Parliament, which is the 2002 Act, and a particular section in that Act lists what is to be known as immigration decision. So if a decision doesn't come specifically within that section, I believe it's section 82, if it doesn't come within that section, it is not an immigration decision, and therefore someone may not get a right of appeal. But let me go on to say that it's also the fact that under another act, I believe it's the Immigration Act 1971, if you do not have existing leave and you apply for more leave, you've got no leave to be varied. Therefore, if the application is refused, there may be no right of appeal. But that is a right of appeal to the tribunal.
That's correct.
That does not take away your right to apply for judicial review. So you could head up to the High Court to challenge that decision.
Fantastic. But because we know that applications of discretionary leave to remain, most applicants don't have any leave to remain in the United Kingdom.
That's correct.
So that automatically catapults you straight to make application to review the decision of the Home Office, which is called judicial review. Before you do so, the High Court must first of all permit you to make that application. And before it permits you, you must have a very solid argument. And that is where we come in. We can make a very solid judicial review argument and persuasive application before the High Court. Once that is permitted, then we'll go straight to lodge the judicial review application. This stands and that carries on. And sometimes the individual will get himself, getting much better result than sitting down doing nothing. Now, Mr. Wallaby, we talked about the right of children and the rest of them, those who are unaccompanied and those who are accompanied as well. In this circumstance, it's very important that children who are under 17 years that have come to this country, that what if those who have been in this country living with their parents or living with their not the parents in this instance, living with relatives, they are under 17 years old and they've come in here, they're not asylum seekers, but have no leave to remain here. Can they make any discretionary leave application?
Absolutely, and from my experience, and I mean this is really my experience, I would encourage a child in that position to seek to regularize their stay as soon as possible. The reason why I'm saying this is it becomes exceedingly difficult to get into university nowadays if you've been living under the radar, and it's causing a lot of problems out there. So if there's still a chance for someone who is a minor, and in this country a minor is someone who is under the age of 18, to go out there and make an application to have their status regularized, and they stand a likely chance of being granted discretionary leave to remain. My advice is speak to a solicitor, call the number on the on your screen right now, get legal advice.
With Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Matafuro, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.